Hello friends. Today we're going to discuss about medical negligence in doctors in training. That means whether an MBBS student or a house surgeon or a postgraduate MD, MS or a DNB student can be held negligent in the court of law will be discussed in this video. I am Dr. Suresh Badadmat, Professor of Psychiatry, working at National Institute of Mental Health and Neurosciences, Bangalore. In this video, I'll be discussing about the medical liability with regard to doctors in training. That is, what are the different case laws in the doctors who are in training held liable in the court of law? What are the research with regard to doctors in training, legal liability, and the recommendations will be discussed in this video. In this contemporary world, the incidence of medical malpractice litigation is increasing phenomenally. So, the concerns and fears about the liability of undergraduate MBBS students, postgraduates, MD, MS, or DNB students, liability for medical negligence also has increased. Although these residency programs in medical colleges and hospitals are vital component in the education and training of physicians for independent practice and to take care of public health. There are many undergraduate medical students. It can be MBBS, it can be nursing, it can be radiography, allied healthcare interns, and also many postgraduates. It may be MD, it may be MS, DNB, diploma, and also DM. These many students are providing services across the country. At the same time, the government of India is planning to start medical colleges in every district. That means there will be many students providing care. Further, National Medical Commission has also given permission to start postgraduate in every corporate hospitals. That means the number of cases on these students and PGs can increase. Further, the Consumer Protection Act 2019, the pecuniary jurisdiction has been increased in the district court up to 50 lakhs, at the state consumer forum up to 2 crores. That means the litigation will increase. But however, these Consumer Protection Act are the only way where the patient's rights can be ensured if there is any medical negligence through compensation. If you look at the prevalence, especially in United States of America, less than 1% of the undergraduate or the postgraduate have been sued in the court of law. However, various states have said various doctors in training have been taken to the court. Only 1% have been sued. However, no data is available from India. Now the question is whether an MBBS student can be sued for the medical negligence. Can a house surgeon who is doing compulsory rotating medical internship can be held negligent in the court of law? Can a postgraduate student held responsible for medical negligence? Those will be discussed from various case laws. The first case, Collin versus Hertfordshire County Council. This case occurred in 1947. Here, Mr. Collin was undergoing an operation in a county council hospital. The operating surgeon, who is qualified, ordered procaine on the telephone. The house surgeon took the orders and misheard procaine as cocaine. And this house surgeon placed an order to the pharmacist to dispense cocaine. The pharmacist, without asking for any written prescription, he dispensed cocaine. Without any prescription, and also the orthopedic surgeon gave an injection which was mixed with cocaine. Unfortunately, the patient died. Now, this county council hospital, along with the doctors, were taken to the court. In the court of law, the question was, who will be held responsible? Is it the county council hospital or the operating surgeon or the house surgeon who is a trainee or else the pharmacist who is a full time? In this case, the operating surgeon was a part time locum. That means it was a contract for services. That means per case he was hired. The house surgeon was a trainee, whereas the pharmacist was a full time. That was contract of services. That means employer employee relationship was there. Now the question is, who should be held responsible? In this case, the court was categorical. It clearly said the hospital authority is liable for the negligence of the professional men employed by the authority under the contract for services as well as under the contract of services. That means whether he's a permanent employee or else he's a part time employee, whether he's a trainee or else he's on a contract basis, the hospital will be held responsible vicariously. And in this case, vicarious liability played a role, and the hospital and the doctors were considered negligent under the civil case. Now let's understand what is this contract of services and contract for services. In contract of services, there is employer-employee relationship. That means master-servant relationship exists. That means a contract of services is an agreement binding a parties who are commonly referred as employer and employee. Whereas contract for services, a relationship akin to agency, generally person engaged via a contract for services. That means here an anesthetist can be hired for providing his services for particular case only. After that, he will be gone. That means he'll be hired as on contract. In contract of services, there is a master and a slave relationship, that is employer-employees relationship. There is a complete control over the employee. Here the process of engagement of the working person, hiring him, controlling him, regulating him is completely in the hand of employer. Whereas in contract for services, he is hired for particular important issue which is part-time and engagement is limited. Hence the control is also limited. Hence, my dear friends, as per the case, both contract of services, contract for services, including the doctors who are in training, will be held responsible under the civil law. There was another important case, Sentman versus Cobb, in 1991 came into picture. In this case, it was an alleged lithium poisoning by two first-year psychiatric residents. Here, the two psychiatric residents gave higher dose of lithium, which led to lithium toxicity and also various neurological deficit it occurs. In this case, the court held that as a healthcare practitioner, a first-year resident who assumes to treat and care for the patient means that they are the reasonable and ordinary qualification of her profession and that she will exercise a reasonable skill, diligence and care in treating the patient. That means although they said that they are psychiatry residents, that means they are PG students. by the virtue of being the student in particular speciality, and they are going to become the psychiatrist. By the virtue of that, they will be valued and assessed as a psychiatrist. That means they were not spared. They were sued in the court of law. The residents treat the patient and prescribe the medicine, holding themselves to be a psychiatrist. They do not represent, telling that I am a trainee, I am a student, hence I am examining you. They do not say that. When the informed consent is taken, they will say, I am a psychiatrist. And the patient comes to the hospital thinking that a qualified psychiatrist will be treating them. Hence, logically, the court held that whether it is a psychiatric trainee or else a qualified psychiatrist, all of them will be held under the same ambit, telling that they will be tried as a specialist. Hence, the court was categorical, telling that they are a specialist, hence they will be held responsible because they are working under the supervision. If the supervisor is not there, the PG has to discuss and inform the superiors. Then only they have to give the prescription. They cannot act as a independent psychiatrist. Hence, in this case, my dear friends, the court held the postgraduates responsible. Another similar case, Gonzalez versus St. John's Hospital and Medical Center, 2007. In this case, a third year student in super specialty of colorectal surgeon did a surgery. In this colorectal surgery, iliac artery was damaged. There was a massive bleeding and the patient died. Patient's family went to the court and said that this person who did the surgery was doing super specialization residency. He was not qualified to do this surgery. Hence, a medical negligence case is evident. In this case, the court looked into the matter. Here, the surgeon who had done his MBBS, who has done his general surgery, was doing super specialization. Hence, the court said he was a qualified doctor. He was doing super specialization. That means he will be treated as a colorectal surgeon. And the court said that those residents who limit their training to a particular branch of medicine or surgery and who can potentially become a board certified in the specialty or specialist for the purpose of standard of care. And in this case, he was not held responsible. That means, my dear friends, the court is very clear. Even though they are students, they are undergoing training, they will be considered as a specialist. Hence, they have to bring reasonable degree of care to the table. In this regard, there was an important publication done by Wegman and his colleagues in 2012. This article was published in Clinical Orthopedics and Related Research in 2012. The title of the study is Medical Liability of the Physicians in Training. In this, author examined the legal cases in which the standard of care for a physician in training has been questioned. In this, the authors did a thorough review and looked into various databases and found 15 case rulings where the junior doctors were named in the case. And they also considered 10 law papers directly related to the subject of legal liability of the physician in training form the basis of this article. In this study, the authors also tried to look into the papers where the residents' conduct extended the liability for the supervisors and also the hospitals. They also looked into how the court deliberated and applied law based upon the factual circumstances of the case. That means author looked into what was the legal reasoning in this case. The authors discussed various things and concluded that the courts have struggled with the question what standard of care should be applied to the undergraduate, postgraduate students who are undergoing training. Unless a resident, that is, a student or a PG, a physician specifically discloses the training status to the patient, most courts have held that the reasonable standard against which a resident conduct is measured is that of a licensed practitioner in that specialty. What does it mean? It means if the PG does not disclose he is a trainee, he is a student, he continues to behave that he is a qualified specialist, then the court will hold him as a specialist and the standard of care applied for assessment will be of a specialist. Hence, during the informed consent, the PG should mention that I am going to do ABCD, but I'm a first year trainee or else a second year trainee, and my supervisor is Mr. So and so, and he will be supervising your case. This legal reasoning accommodates the fact that residents hold themselves as a complete practitioners in front of the patient, and the patient does not know that he is a trainee. Hence, the court was categorical in most of the cases and said the trainee will be treated as a specialist. That means the courts across various cases, the logical reasoning was none of the students disclosed that they are trainees. Further, the regulatory authorities mandate the graduate in the medical training for a close supervision from a qualified specialist. And invariably, these institutions file affidavits telling that we have adequate number of supervisors to supervise these trainees. Hence, it is reasonable to use the standard of specialist whenever there is a medical negligence case is there. Further, a logical proposition is by holding the postgraduate students equivalent to specialist, that means these postgraduate students have to raise their standards whenever they are in doubt, has to go to the supervisor, and the supervisor has a duty to supervise these postgraduates. Hence, the patients who approach these teaching institutions should be given reasonable degree of care. Further, another important study by Kachelia and Sturdert, published in JAMA in 2004. The title of the study is Professional Liability Issues in Graduate Medical Education. In this study, the authors concluded physicians in training are generally held to the same standard as of a supervising physician in their respective specialty. This principle encourages the physician in training to seek supervision from the supervisor so that the patient who approach these training institutions get a reasonable degree of care. Further, supervising physician will face a malpractice exposure not only for the care they provide, for also the students if they don't supervise them properly. And in the absence of supervisor, if the trainees do certain procedures, the supervisor and also the hospital will be held vicariously responsible. This was the conclusion under this study. However, there were serious unanswered questions which needs to be answered. What constitutes adequate supervision is not been settled till date. What are the adequate working hours for the trainees in India is not yet been established and followed adequately, standardly across all medical colleges under DNB boards. What should be the working load? How many cases a doctor can see? How many cases a trainee can see? What is the safe work environment? And what are the circumstances in which this negligence occurred? Whether it is an elective case, whether it is an emergency case, whether the supervisor was absent, whether the hospital did not have adequate number of supervisors, and how we need to assess the negligence has not been answered. However, there are certain remedies based upon various literature has been proposed. Medical Council may mandate that medical colleges to provide doctor in training with professional liability insurance to cover all claims arising within the scope and duration of training. That means all these medical colleges, hospitals who train should cover with indemnity insurance for all these PGs. In New York State, the Department of Health adopted, as a part of a administrative health code, a regulation limiting the junior works schedule 80 hours per week with a consecutive call limited to 24 hours only. Further, some states have mandated indemnity insurance for postgraduate trainees also. In the past, some courts accepted the argument that doctor in training comprise a discrete practicing community and accordingly held that standard to be applied was the resident physician with similar training and experience in that field. The rationale for insisting on this relatively high standard for resident physician appears to be grounded on the policy consideration that all this PG training institute has an adequate number of supervisors. However, these PG trainees can also be sued under the common knowledge doctrine when there is an error, complication, or a misdiagnosis, which constitutes an obvious violation of any reasonable standard of due care. The court permits a laypersons to rely upon common knowledge to evaluate the doctor in training conduct. What does it mean? In a simple example, any doctor, before giving a penicillin injection, has to give a test dose. If it does not do, that means any doctor in any year of training will be held responsible under common knowledge doctrine. Further, however, these standards of care are not static. It is based upon the case by case basis. What are the circumstances involved? How many supervisors were there? Whether it is an elective procedure, whether it is an emergency procedure, what was the situation, where was the patient who came for care, and various other factors based upon patient's condition, whether family members were available, whether the past records are available. We need to assess the case based on all these circumstances. Hence, there is no single formula or a straitjacket formula to assess medical negligence in students or doctors in training, that is, postgraduates. To conclude, the hospital authority is liable for the negligence of professional men employed by the authority under the contract of services or for contract of services. That means both permanent employee, contract, or else ad hoc basis, or else subcontracting. All of this, people will be held responsible along with the hospital. Invariably, the UGs, postgraduate students, may not come under the ambit of contract for services or contract of services. But they will be held responsible because these postgraduate institutes have taken permission to do training by telling that we have adequate number of supervisors. Hence, if there is failure in supervising the students, the hospital and the supervisors can also be held responsible. UGs, housemans, and the PGs are meant to be trained. They cannot be used as an agents to gain revenue generating people. They need to be trained. Hence, the supervisors should be available. Accordingly, various courts have held that postgraduates who are being supervised, hence these PGs will be held accountable as the same standard of the specialist in the same area. Hence, proper supervision is mandated under the NMC Act and specific regulations. Hence, to conclude, my dear friends, the postgraduate students, undergraduate students will be held responsible under the civil law along with the supervisors and also the hospitals and medical colleges. Thank you very much for giving your valuable time. Stay safe.